We are observing the process all together. And for us, it's extremely important that all of you got involved today and you're ready to participate. Sometimes maybe very passive participation today, but still we have the Zoom opportunity available with us, and you can also ask your questions in the chat bot for today's event, and you have found an opportunity to get involved with us today. So I take this opportunity to open our today's congregation, if I can put it this way. It's entirely different circumstances which force us all out of the comfort zone in a way. And you must be mindful of the fact that we planned to see each other at the end of March here in Kiev. And we hope to see you and greet you with our flowering chestnut trees, and to have this wonderful workshop taking 2 days. But unfortunately, the events beyond our control ensued, and we had to change the format due to quarantine restrictions. But I hope that this is not going to prevent us from holding this qualitative discussion. And yet again, let me express my gratitude for agreeing to discuss very important for us, for our practice issues, the enforcement of human rights, which are universal in the understanding that it relates to each and every one of us. And now I would like to reiterate again and to speak about the topic of our today's workshop, which is the international workshop, the legal consequences of declaring a legal normative act as unconstitutional to protect human rights in administrative justice. And as the moderator today, I'm Miroslava Bilak. At the same time, I'm also a judge within the Supreme Court of Ukraine. I will be moderating our today's event, our today's discussion. Today's meeting is dedicated to retroactive action or retrospective application of the Constitutional Court of Ukraine's decisions on the unconstitutionality of laws or other regulations. This is a very important topic for protection of human rights, and it gives us a possibility to restore humans to their rights. This is the fact about restoring the fair treatment of a person. As a general rule, laws have no retroactive action, and this is spelled out in virtually all constitutions. And in essence, this principle provides for legal certainty, and it helps to ensure both societal stability and the stability of judicial practice, thus ensuring that there is stability for the judicial practice as such. Several years ago, the Constitution of Ukraine was amended, which introduced a very important democratic instrument or institution to enforce human rights, the instrument of constitutional complaint. The institutional complaint as an instrument is a highly important instrument to enforce human rights, because once again, it provides us, an individual and the citizen, the opportunity to apply to the Constitutional Court under this procedure and directly appeal a law or a separate provision to declare it as unconstitutional. According to the Code of Administrative Procedure, courts apply the rule that was in force at the time of the legal relationship. And this raises the question in its turn of what is the benefit for someone who has obtained the desired result of the Constitutional Court at first glance, but hasn't been reinstated to their rights. Or if it's not a constitutional complaint procedure we're talking about, but rather an abstract normative control procedure, if we can put it this way, if a person also cannot use a decision of the Constitutional Court to declare this law or provision unconstitutional. That is to say, an individual has a decision about the unconstitutionality, but the effective reinstatement or restoration of human rights, this individual unfortunately doesn't enjoy. In Ukraine, there is a principle of the rule of law, famous and commonly known in the world, which first of all aims to ensure fair treatment and justice of a person. And this principle encourages this discussion of retroactivity. For the correct application of this concept or the doctrine of retrospectiveness, it's necessary to answer a number of very important questions. which first I would like us to emphasize now. Is retrospectiveness needed in Ukraine? If so, when is it justified and appropriate to ensure the rule of law? What are the risks of introducing retrospectiveness? Can it be the rule or is it just the exception? And most importantly, what mechanisms should govern its application in order to truly ensure the rule of law and the protection of human rights? At this point, I would like to announce and introduce to you our panelists, famous international experts, judges, who are involved in our event today. First and foremost, it gives me a great pleasure to introduce to you the participants of the first panel session. This is Mikhailos Mykovich, President of the Administrative Cassation Court within Supreme Court of Ukraine, Doctor of Law. Mr. Serhiy Halavati, Deputy President of the Constitutional Court of Ukraine, Professor, member of the European Commission for Democracy through Law, Venice Commission, and Doctor of Law. Virgilijus Valančius, Judge of the Court of Justice of the European Union, former President of the Supreme Administrative Court of Lithuania, Dr. Lars Broka, President of the Constitutional Judicial Chamber and the High Administrative Court of Rhineland-Pfalz, Germany, who is right now taking great care in order to quickly join our event today because he's unfortunately stuck in a traffic jam. Dr. Eva Wendler, Judge of the Federal Administrative Court, Graz Office, Austria. I will allow myself to be very brief and to say a few words for our speaker panelists, as well as for our audience who are listening to us very attentively. Once again, I would like to emphasize the main components of our today's agenda, which I hope all of you have already been acquainted with. I will only stop and linger a little at the structure, because for the most part, everyone has this program before themselves, and you can focus on the specific part or the panel that you are interested in, or this panelist that you would like to listen to, thus to focus your attention in a greater detail. Therefore, our today's meeting, our today's international workshop will consist of two sessions. The first session is called The Retroactive Effects of Judgments of the Constitutional Court upon the Protection of Human Rights. And the second section is called The Mechanism of Reviewing Judgments Under Exceptional Circumstances, Part 3, Chapter 3 of the Code of Administrative Procedure of Ukraine. I think it will be very exciting, interactive, will be very rich. After I briefly outline the main ideas for our today's agenda, we will also launch an interview, a questionnaire, which will allow us, the speakers and the organizers, to understand how the audience takes the questions that have been already asked beforehand in this program. And at the end of this session, we will also be able to once again see the results of this interview, of this questionnaire, once again to see whether we have been convincing enough and our reasons have been cogent enough of our points of view. And it will also be greatly interesting for us to see the results of our morning session. Thank you. In other words, there is an online interview. There will also be topical video presentations by our presenters who were so courteous as to record these video presentations. We really thank you for your time that you took in order to make these recordings. And you have been able to fulfill what we have planned for this particular workshop. And we hope that a wider audience will have access to these materials that will be posted on the official site of the Supreme Court of Ukraine. Well, the panel discussion itself, you will be able to see a few PowerPoint presentations involved in it. These are the PowerPoint presentations that will contain certain quotations by our speaker panelists who were announced in the first format of our event, which was supposed to have taken place in March. Unfortunately, the people that were planned for this Zoom format, some people weren't able to get involved, but at least they provided us with their materials. And they thought it was expedient for us to provide their main thesis. And this will actually allow us to add a new color into our discussion, I hope. The two sessions are structured in the similar manner. And we wanted to make sure that both our audience that are watching us and listening to us and are interested in the subject matter, and the people who are not participating would get involved. So something I would like to stress now is we are being listened to and watched by 105 participants who have got registered and made time to get involved in today's discussion. You can just imagine what great interest this has caused with our esteemed audience. And let me reiterate myself and say that these are professionals, these are judges first and foremost, these are academics, as well as representatives of the Bar Association of Ukraine, attorneys, lawyers, who are eagerly interested in the process which is running right now in the judicial practice of Ukraine inclusive. Also, before I give the floor to Ms. Maria, who is the technical moderator, for her to speak about the legal rules, legal points that all of our participants have to be familiarized with, something that I would like to speak about finally is that our esteemed audience can ask your questions in the chat box. You have also been acquainted with the video about how to use it, and I hope that Ms. Maria will also repeat and reiterate some of the points. So now, Ms. Maria, the floor is yours. Thank you very much, Mrs. Miroslava. Good morning, dear participants. Now the interpretation is off so that all of the participants can listen to me. Once again, good morning, dear participants. I would like once again to remind you about the interpretation settings if you haven't done it yet. First of all, on your panel, you have to press the button Interpretation and select Spanish for Ukrainian interpretation, and also depress Original Sound. Now, concerning the main rules, only speakers and moderators have their microphones and audios on. In order to communicate, please use the chat box, and in order to ask questions of the panelists, please use the function of question and answer. You will find both of these functions at the bottom of your screen. Also, during this event, there will be interviews held. As soon as it is launched, you will see the box with the questions and options for your answers. So please select the answer and press the button to submit. So thank you very much indeed, and I wish everyone a very nice mood. Thank you, Ms. Maria, for this information. I believe that it will be helpful to find your bearings, how to express yourself within the format of our workshop, and we would really like to hear from you today. Also, at this point, I would like to point out that all of the efforts that you have made in order to present the videos and the collection of the materials that I have briefly mentioned, they haven't gone to waste. And now we are preparing the publication of this collection of materials, also the materials that you have provided us with, where you expressed very explicitly your position with regard to the main questions that we asked you beforehand. This collection of materials will be published within 2 weeks, I hope, and I will be happy to send it to you. Also, everyone who is willing to have it, you will be able to get acquainted with it online. And we would also like to have the presentations of our foreign speakers published. They will be published both in Ukrainian and in English. And those speakers who have developed their materials in Ukrainian also provided us with an opportunity, timely opportunity, to organize these materials, and they will also be published. and all of the brief information prepared by the authors of these materials will also be disseminated. So we will preserve, copy, and disseminate this information. And we are very grateful for that. And now it gives me a great pleasure to move on to the next part of our discussion. It's always a great pleasure, because here we will be speaking about welcoming speech. Another welcoming speech, it's like a road, sign road. Now I'd like to give the floor to the President of the Administrative Cassation Court of the Supreme Court of Ukraine, Mr. Mikhailos Makovich. Please, the floor is yours. Thank you. Good morning, everyone. My dear friends.
Thank you very much.
It's a great pleasure.
Hello, everybody, dear friends.
That all of you are
I'm
participating
very pleased
in today's workshop.
to see you all.
Very gratified that you have agreed to
I was pleased to
participate
learn
in this
that you kindly
discussion on
agreed
this extremely important issue, which right now is really acute for administrative proceedings in Ukraine. And
this is very important for
justice,
efficient administrative justice, including constitutional
justice. That's why a great thank you to everyone who is featuring in today's event. The importance of this event will be talked about at greater length as we discuss problems which are part of today's event agenda. Besides,
that we intend to discuss. In
I would
addition,
also like to
I'd
extend
like
my
to
gratitude
thank
to all our
partners.
who have
This is EU project, Right in Justice. That's the Council of Europe projects and support of constitutional and legal reforms, constitutional justice, and assistance to the Parliament and implementation of reforms aimed at improving the efficiency. Projects OIC coordinator in Ukraine, International Fund of International Cooperation, and Ukrainian-Canadian project in support of judicial reform. Well, in spite of all these quarantine restrictions, we still find opportunities to communicate in this way. And in spite of the fact that sometimes the politicians in Ukraine tend to forget about the courts where they state that everything works well, because Ukrainian society, public is always sure that no matter what restrictions we have in Ukraine, the courts will be remain operational. It's a pleasure for me to hear from responses from our foreign experts who kindly agreed to participate in this event, because for us, for judges, to hear your opinions, your thoughts, it's all very important, because as of today we have many categories of cases and conflicts that we need to consider and to examine, specifically after constitutional court judgments have been delivered and declared respective legal provisions unconstitutional. So since we do not have too much time, I'm quite limited, I know, in time, so I want to wish you all very fruitful cooperation and work. Thank you, Mr. Smukovich. Now I want the audience to be very attentive, because now you'll see on the screen online questionnaire for participants. Here, the following questions will be presented. In your opinion, the retrospective application of a judgment determined an act unconstitutional in order to protect human rights is entirely appropriate, possible in exceptional cases for exemption in order to restore justice, or is it absolutely unacceptable? Please, we are waiting for your votes. You can see that the answers to the question about appropriate retrospective effect of discussion is quite acceptable, 33%, possible in exceptional cases, 72%, absolutely unacceptable 5%. Please keep in mind this picture. By the end of the session, we will put it back on the screen, and by the end of the session, we'll do another round of voting, and you will be kindly again asked to join. Thank you. Now we are moving forward with speeches, and now I would like to invite Maria to put on videos who were previously recorded by our key speakers.
Happy once again to be in touch with the Ukrainian audience. Today's topic, impact or legal effect of Constitutional Court judgments on administrative courts judgments, is very interesting, very sensitive, and very delicate. I could share my personal experience as a former administrative judge in my country. And here, when I talk about this subject, first of all, the first idea comes to my mind, the issue of effect. The issue of effect in time, whether it's inter partes, whether the effect ergo omnes, how it affects a current pending case, what effect might be to previous cases, to future cases, and so on. Issue of practical implementation is always very important, very sensitive, very delicate. And this is linked with the issue of clarity, of legal texts, and also of the judgments of constitutional courts. And if we're talking about the supranational level, the clarity of the judgments of the Court of Justice of the European Union or judgment of the European Court of Human Rights. When we talk about a legal effect in time, in my country, we follow so-called Austrian approach, and constitutional court judgments, this is enshrined in our constitution, have not only erga omnes effect, but also it has a snunk approach. It means that from that moment when the constitutional court judgment was rendered and legal act annulled, that act cannot be implemented. And of course, as you know, the devil appears in detail, and there are various different situations. For instance, in 2004, we faced for the first time in my country the situation when we had several applications. We suspended those cases addressed to the Constitutional Court and received the Constitutional Court ruling, and then we decided those cases adequately according to the Constitutional Court ruling. But the issue came up later on what to do with the thousands of previous cases which didn't reach the courts, and the public administration decided these cases, and there were no possibility for individuals to get, if I may say so, the justice in their own case in the same manner than after the Constitutional Court ruling appeared. So, and here, sorry to tell this, in most situations there is, and the only possibility to say the train has already passed. If you didn't respect time limits, if you didn't address the court, sorry, that means there is no real remedy to achieve your goals. Another important issue when we talk about this subject, I would say, is what kind of theory, what kind of doctrine we are following. As you know, nowadays, before we used to have common law doctrine, civil law doctrine, Now we have more and more convergation, and we look at each other's judgments and decisions. Constitutional courts are doing the same, administrative courts doing the same, and supranational courts cooperate in the same manner. Of course, we try to avoid discrepancies in probably interpreting the same or similar legal texts. But we shouldn't forget that there are very rare situations, so almost impossible to have extremely the same situations, because at the EU level, for instance, we have directives, regulations, other acts for interpreting. The European Court of Human Rights, they have their own convention. At the EU level, we have the Charter. So, and here I can understand that sometimes for administrative judges in Ukraine, it might be a bit difficult to understand which approach to follow. The Strasbourg Court approach, European Court of Human Rights, or Constitutional Court approach of Ukraine, in particular, when there are slight differences in interpretation application.
First of all, I would like to thank the organizers for inviting me to contribute to this workshop, as well as for having chosen this topic for discussion, which can be summarized in one question. How can an individual profit from a ruling of Constitutional Court which finds a legal provision unconstitutional? On the one hand, from the perspective of an individual, it is hard to explain how one can be bound by a judgment based on unconstitutional law. On the other hand, one of inherent principles of the state and the rule of law is legal certainty, which also prohibits the retroactive effects of legal provisions. In my written contribution, I analyzed both the temporal effects of judgments of the Constitutional Court of Lithuania, this is the jurisdiction which I'm originally from, as well as judgments of the Court of Justice of the European Union, which is the jurisdiction I currently represent, and I'm joining you from Luxembourg. Why the analysis of temporal effects of judgments of the Court of Justice of the European Union could be irrelevant for today's workshop. First of all, because this court carries out functions which to some extent could be compared to functions of constitutional dimension. As such, it can annul acts, legislative acts of general application, which are in contradiction with the primary EU law, with the founding treaties of the European Union, or with the general principles of the European Union. It also gives binding interpretations to the real content of the European Union law in its preliminary rulings when asked by national courts. If the Court of Justice gives a new interpretation of European Union law, is this interpretation applicable only for the future, or does it also have retroactive effects? The general answer is yes, it also has retroactive effects. In accordance with the settled case law of the Court of Justice, an interpretation it gives to provisions of European Union law, and I quote now, clarifies and defines its meaning and scope as it should have been understood and applied from the time of its entry into force. It follows that law interpreted this way, courts should and must apply also for the legal relationships existing before that new interpretation. Hence, the new legal interpretation will be applied both for the future as well as retroactively. At the same time, in exceptional circumstances, the court retains the power to limit retroactive effects of its judgments in order to preserve the certainty of legal relationships formed before the new interpretation, or to avoid other unintended circumstances, such as heavy costs on the economy. But I must admit, these instances are very rare. At the same time, the European Union law does not impose any obligation on national courts to revisit their rulings in the light of these new interpretations. The Court of Justice recognizes the importance of the principle of res judicata on both the European Union level and at the level of the law of its member states. Thus, in order to ensure both stability of the law as well as legal relationships and the sound administration of justice, it is important that judicial decisions, which are definitive, they can no longer be called into question after all rights of appeal have been exhausted. Therefore, the European Union law does not require a national court to reopen proceedings, even if to do so would remedy the infringement of the European Union law. This is the balanced solution between individual remedy and legal security.
First of all, we are talking about looking for balance in order to ensure the legal certainty. So we are looking at for proper channels in order to ensure the protection of human rights. On the other hand, this is also about distinguishing functional spheres of constitutional and administrative jurisdiction. So here we are talking about the mutual respect and accounting for mutual interests. So in brief, this is the way to maintain constitutional order in Ukraine with protection of human fundamental rights. So this is also a way to restore the substantive justice. And this is a huge benefit of the law. Actually, to find the proper resolution of this conflict is the issue to be solved by the lawmakers. Actually, there are very few exceptions from this principle. Let's say in the German law, a big deal of attention is paid to legal certainty. So here I would draw your attention to Article 5 of the Administrative Code of Ukraine, where this article actually does not leave too much space for legal certainty. So actually the Constitutional Court also can put some time limits, time restrictions on unit of the effects of its judgment, say, for example, with regard to the effects of certain law.
I would like to give some remarks on the issue of our workshop from my Austrian point of view. In Austria, there are 3 legal regimes relevant in the area of fundamental rights. These are the Austrian Constitution, the EU legal regime, and the European Rights Convention. It is important to note that the European Rights Convention is part of Austrian constitutional law. Furthermore, I'd like to point out that we do have a constitutional court in Austria. This shows a structural difference compared to other countries in Europe, such as Greece or the Scandinavian countries, for example. The Constitutional Court has a broad variety of competencies and plays an immensely important role in the framework of fundamental rights enforcement in Austria. The Constitutional Court has the sole power to scrutinize the constitutionality of laws. All other courts are prohibited to do so. The competence to review fundamental and human rights violations with regard to administrative court rulings has become the most relevant competence of Constitutional Court in recent years. As I mentioned before, in Austria, convention rights are regarded to be part of the constitutionally guaranteed rights, and thus the convention rights are as well a standard of review of the Austrian Constitutional Court. So how does the Austrian Constitutional Court become active? I will focus on the situations which are relevant in our context. The review of statutes is made possible by a complaint, for example, of 1/3 of members of a parliamentary chamber, or a complaint can be filed by an individual. In this case, certain restrictive requirements must be fulfilled. The review can also be based on concerns of constitutional court itself, or on concerns of administrative courts or ordinary courts. If there is a concern, the judge has to submit a formal petition for judicial review of the law and its constitutionality for the Constitutional Court. The Constitutional Court can declare a statute as unconstitutional and void. The effect of the judgment is usually ex nunc. However, the court may postpone this effect up to 18 months to grant the legislator an opportunity to repair the faulty law. If a time limit is set, rescission enters into force only after expiry of that period. For this period of time, the statute which was declared unconstitutional remains applicable. Unless the Constitutional Court pronounces otherwise, rescission is not retroactive, except for the case in point. The Constitutional Court also secures the constitutionality of administrative court rulings. A complaint requesting judicial review of administrative court rulings has to allege a violation of fundamental rights, including rights enshrined in the European Rights Convention, or has to argue that the decision was based on an unconstitutional statute. If the Constitutional Court finds an infringement of fundamental rights, it quashes the ruling and refers the case back to the administrative court which issued the ruling. The administrative court has then to render a substitute ruling in compliance with the findings of Constitutional Court. Therefore, to sum up, the Constitutional Court is the only organ within the Austrian system, which is allowed to decide on the constitutionality of national laws and administrative court rulings. Unconstitutional laws must not be left unapplied by judges, but they must initiate a specific proceeding before the Austrian Constitutional Court. So looking back, yardsticks and standard of review of the Austrian Constitutional Court are constitutionally guaranteed rights, including convention rights, and the whole Austrian Constitution as such.
Maria, we have finished the reviews of our videos.
We have just finished. We have just seen one of the videos of one of the panelists, who unfortunately haven't been able to listen to us, but he has expressed his opinion in the materials, which will be later published. So you will be later on able to revert to his position, which has just been announced. At this point, if we are ready, and if our panelists and speakers, once again, I would like to repeat that Mr. Broker cannot reach his office for the reasons beyond his scope of control. We hope that possibly he will join us a bit later. Now, dear colleagues, we are moving on to the panel discussion. I would like to encourage all of you to be active. And now we have Mihailo Smakovich with us, Serhiy Kolovati, Virgilius Valancius, and Eva with us as well. So would you kindly respond to what has been presented? Can you hear everything? And let us move on. Everyone is on. Have you given me the floor yet? Okay, thank you for giving me the floor. Within the framework of our topic, I would like to express my separate views concerning the ideas which are the topicality of this highly important event. First of all, I would like to stress your attention on the necessity to shaping and ensuring unity of case law and judicial practice in Ukraine. Because the practice of judicial practice has to be based on the administrative proceedings and has to develop in systematic connection with the doctrine of law as such. The position of the Constitutional Court of Ukraine says that justice is recognized to be just only if it is in compliance with the norms and requirements of fairness, and it restores humans to their rights. But with the development of humanity, the change in judicial practice can also take place in certain issues, in certain points. Sometimes it even becomes unavoidable, but anyway, it has to be well-grounded, reasoned, sequential, and well understood, not only by academics and specialists, but also average citizens. So the change of practice of the judiciary cannot be arbitrary. It has to be based on objective foundations, for instance, amendments to legislation or circumstances, the due understanding of the content of the law or inadequate understanding of the norm of law. So the theory of the doctrine requires a holistic doctrinal legal platform that has to become undeniable and universal foundation for administrative justice practice. And what I have just cited above, in order for administrative courts to resolve their cases which are to do with legal consequences, which can ensue if the Constitutional Court of Ukraine initiates proceedings, this requires certain legal platform of both legislative and procedural character. We're talking here about some cases where still some issues remain pending. So can we use retroactive effect of decisions concerning recognizing an act as unconstitutional in order to restore human rights? In what way should human rights be restored, which were violated by an unconstitutional law, by the inactivity of authority or by an official. And in connection with this, we also have some other interconnected logical questions. How can we ensure that the judgments are enforced, adhered to, and the conclusions of the Constitutional Court of Ukraine are also complied with by the administrative courts of Ukraine if we have, unfortunately, a lot of under-regulation in our practice? Second, what should the format of the activities of the procedural justice be in Ukraine, especially within the framework of a constitutional complaint, if the Constitutional Court of Ukraine recognizes a certain norm of provision of law unconstitutional, with regard to which a final decision has already been adopted, but the final decision hasn't been enforced? Thirdly, what should the format of the activities of the judges of administrative court should be if the Constitutional Court recognizes a certain law, regulation, or a bylaw as unconstitutional, and which resulted in the violation of fundamental natural human rights, etc. These matters and others are a cornerstone of the system of the national statehood building, and the practice bears witness to the fact that the practice of this kind frequently goes beyond the scope of discretion of administrative courts, which belong to the judiciary of Ukraine. Secondly, there is an objective necessity to analyze the peculiarities of applying the mechanism of protecting human rights in the context of court judgment review and revisions in the light of exceptional circumstances. The practice in this area within our court system, unfortunately, is virtually nil. It is just being framed. Therefore, the expected result of our today's event will be shaping a certain consequential position on this particular matter. Let me remind you that all of the procedural codes have been amended duly, and one of the grounds talking about the exceptional reasons is the adoption of the rule by the constitutional law and recognition of a certain law, act, or certain provisions in this law as unconstitutional when they were applied in the final decision of a case, if this particular decision hasn't been enforced yet. In other words, the lawmaker understands and recognizes that this is the ground and the reason for judgment reviews in light of newly found circumstances, newly discovered circumstances. But this particular norm is absolutely expedient, reasonable, and it's a practical matter because it helps us to enforce human rights in a more effective way. But just as the previous speakers, and I will repeat myself by saying that Law 4144 in the report on the rule of law adopted by the Venice Commission in its 86th plenary session recognized one of the most important elements as the rule of law is legal certainty. And it's the principle of legal certainty which is significant in order for people to have trust in the judiciary as a system and the rule of law. It is significantly important also for the fruitfulness of business activities in order to generate development and economic progress. But for that, the state has to make the legal texts easily accessible. Therefore, predictability must also be present because a law, if possible, must be pronounced before it comes into effect, and it has to be predictable with regard to its consequences. It has to be formulated and shaped clear enough so that an individual can shape their behavior in a due manner. However, despite all these procedural novelties, the legislator unfortunately hasn't made such provisions, and the doctrine of law unfortunately hasn't provided a universal approach concerning the scope of how the scope of human rights, how they should be reinstated if they have been violated. So let me say it in the following way. It's necessary to establish by the Constitutional Court of Ukraine that a certain law is unconstitutional, is deemed to be unconstitutional in whole or in part, because this only gives the right to initiate proceedings in the light of the newly discovered circumstances, but this is not something that makes the court to approve the decision in favor of the individual who files such an application. Second, the decision of the body of judiciary is not supposed to approve of this decision if a person applies, but the restoration of rights is determined at the date when the Constitutional Court adopts this decision. So we're talking about prospective effect of the bodies of constitutional jurisdiction. And the third position is a renewal of the violated rights of an individual in light of the exceptional circumstances. It has to be done not of the date when such a decision of the Constitutional Court was adopted, but from the date when such a fact of violation was recognized. Otherwise, we will be speaking about retrospective effect of the decision of the body of the constitutional jurisdiction. Next, I would like to speak more at length about the legal position of retrospective decision of the bodies of the constitutional jurisdiction. It's true that the violation of constitutional rights and freedoms in a legal state is unacceptable, especially if public authorities are at fault for these violations. Given this, we make a presumption that it's expedient to use retrospective effect to the decisions of the bodies of constitutional jurisdiction. But in my view, such effect of the actions of the constitutional jurisdiction, in my strong conviction, shouldn't be absolute. In my understanding, the lawmaker beforehand has powers and the mandate to establish certain legal filters, first of which is which legal factors condition the necessity to set these legal filters. Second, the establishment of which legal factors is necessary and reasonable in order to understand and prevent retroactive action of the body of constitutional body in the context of the judgment review in the light of exceptional circumstances. Talking about objective factors, first of all, we have to adhere to the fact of res judicata principle, which is primary of all of the principles of the rule of law. I will try to be more brief because time is running out. Second, it's necessary to ensure the principle of legal certainty when we plan and fulfill the state budget. We must also be aware of this because the Constitutional Court identified it in their decision dated 2008, number 26, in the case about balanced fulfillment of the budget. It establishes itself as a legal state, normative state, through the budget. Therefore, these factors have to be taken into consideration. Fifth, the major effect lies in the fact about legal filters, setting of which is reasonable, especially when we want to identify the limits of retrospective effect of the borders of constitutional jurisdiction when we speak about exceptional cases, exceptional circumstances. So the legal doctrine has expressed its opinion and says that these shouldn't be legal rights, but natural rights or social rights that are concerned. But when we look at the decisions of the European Court of Human Rights in point 74, decisions dated 2010, in case Leilas versus Croatia, the European Court identified that state authorities are obliged to implement internal procedures that strengthen transparency and mitigate the number of mistakes and therefore facilitate legal certainty in legal relations. Therefore, the resolution of the matter of legal filters goes beyond the discretional scope of courts and appeals to the discretion of the lawmaker, the legislator, who have to make sure that financially the decisions and judgments will also be enforced. And the European Court of Human Rights, in one of its cases, Sukhanov and Ivchenko versus Ukraine, when denying the application in its part of complaint, they said that there was a lack of natural expectations on behalf of the complainants. That is to say, that there were already limitations set to the payments, and the European Court of Human Rights agreed to that, irrespective of the fact that the Constitutional Court recognized these provisions as non-constitutional even before the European Court of Human Rights rendered its decision in this case. The definition of these filters, once again, goes beyond the discretion. Therefore, these filters have to be set in place by the legislator and not by the general court. And given the fact that my time is running out, as a conclusion, in my understanding, in my view, the retrospective effect of the decisions of the Constitutional Court of Ukraine as of today is permissible. And it is permissible because it's already provided for and established both in the Constitution and in the legislation. However, in such cases, when the decision hasn't been enforced yet, just as it is stipulated in our procedural code, secondly, through the principle of the rule of law, it has to ensure the fundamental human rights, and thirdly, in the manner that restores human rights, in the manner that compensates pecuniary and non-pecuniary damage inflicted on the person as a result of adopting the act, which was recognized as unconstitutional. So this is the legal regulation that we have in my understanding, and the one that we need to adhere to. Concerning the other ones, we require legal filters which will allow courts in other cases also to use the retrospective effect of the actions of the Constitutional Court. However, this is the problem that belongs to our legislator, the Supreme Parliament of Ukraine. Of course, I will continue expressing my position as we go along with our event. Thank you for your attention. Thank you, Mikhailo Ivanovich, for giving this problem such a wide scope and talking so much in detail concerning the problems that we are confronted with in our practice. I would also like to invite our speakers who are ready to speak about the topicality announced in the first session. And now I would like us to talk more about the conceptual understanding.
So I would like to ask you a question with regard to arguments pro or contra application of retroactivity, of retroactive effect, and in the context of the questions raised by our participants, I can see a very appropriate question. If we use retroactive effects, don't we annihilate the principle of constitutional certainty if we apply the judgment of Constitutional Court retroactively?
Yeah, this is a very interesting question. Let me start with one of sayings of famous legal theoretician Hans Kelsen. And he was the pioneer of actually the European Constitutional Courts, first in Austria and then in other European courts after the World War II. The main logic and conceptual thinking was based indeed on Hans Kelsen theory. And he used to say, Hans Kelsen, that if we talk about the application of law, the law should be valid. And the paradigm was like that. The law, we presume that the law passed by the parliament is good unless or till the very moment when the Constitutional Court stated an opposite. And based on this theory, in some legal traditions, including in a legal tradition of my origin country, Lithuania, followed this prospective or ex nunc approach. But as we had, there are some other traditions where a retroactive or retrospective approach is also tolerated. It was quite interesting to see the answers of the audience. If I'm not mistaken, 72% of the answers were in favor of application of retroactive retroactive application of the Constitutional Court judgments in administrative court decisions and judgments. 33% were rather on the to use this approach on exceptional basis, and only 5%, if I'm correct, were absolutely against this approach. In my own country, in Lithuania, it would be rather opposite. I would say probably in 75–80% answers would be in favor of prospective approach, but the rest would be rather for exceptional cases. We could follow ex tunc or retroactive approach. And this is based on our Constitutional Court official doctrine or case law. Our Constitutional Court in Lithuania was set up in '92 and till 2011 was strictly following a prospective approach. And only from October 2011, Lithuanian Constitutional Court recognized that there might be exceptional cases when the retroactive or ex tunc approach could be followed. And I can understand how to say, this approach of Lithuanian Constitutional Court, because indeed there might be situations when, if you are blindly following only prospective approach, you could find yourself in a very strange situation. When, for instance, the law which was adopted many years ago but never reached the Constitutional Court, and many judgments and decisions were already based on this law, unconstitutional law, already declared, let's say, and in particular when it is concerned to the very, very fundamental issues. And the Lithuanian Constitutional Court stated that it might be these fundamental issues should be based on the independence of the country, serious threats for the democracy, and so on. Very abstract criteria, but the doors were opened. What are pluses and minuses, as you put this question? And so somebody from the audience put this question to the panelists. We all agree that individual rights, in particular human rights, are very, very important. But sometimes we face the situation when we, on one hand, have individual rights, on the other hand, we have very serious principles which have already been mentioned today. Legal security, legal certainty, legal stability, and so on. And in this respect, there are certain procedural limits to address, in particular administrative courts. If I'm not mistaken, within 30 days, you are allowed to address the Constitutional Court in Ukraine. In different countries, this time limit might differ, but this is not months and years. It's quite short period of time. The same period of time is let for revision of the already adopted administrative court judgment, or not only administrative court judgments, even other court judgments, after, let us say, a person won or achieved a victory in the Constitutional Court due to his or her individual complaint. And as we had from our German colleagues' intervention, to his attitude, 10 years time limit you have in Ukraine is quite doubtful for his attitude. And of course, there might be different views on this subject matter. But why I am in favor more of ex nunc or prospective approach with exceptional cases to apply a retroactive approach, because, and I do remember, we used to have a number of cases in my country in administrative courts, when if we apply as a rule, as a general rule, a retroactive approach of Constitutional Court ruling, it might cause indeed extremely serious damage, not only economic, but other damage. And sometimes the court system might be not, how to say, might be overloaded, and it would be very difficult for the court system to take this charge. And in Ukraine, I remember we still have this situation when after so-called social or demagogic laws, sometimes foreign experts called it like that, the previous governments adopted, and the courts, administrative courts, are stamping judgments according to the law, but state has no possibility how to implement them, and postpone, and now we're in the vicious circle, and the European Court of Human Rights in Strasbourg is looking at this situation, and so on. So to put in a few words, I see that probably there are less damages when we use prospective approach with an exceptions, rather than we use retroactive approach almost in all situations. So, but again, it depends on legal traditions. If, for instance, Ukraine is sure, and judicial circles, Constitutional Court and administrative courts, they see some more advantages in it, and are sure that it might be effective to do it, why not? But I have some doubts as far as the effectiveness of this approach implementation. Thank you.
Valančius, thank you very much, Mr. Valančius. I'd like to invite Evra Vedler. Eva, what are the criteria that the judges in your country are guided by when they decide on whether retrospective approach would be appropriate in specific cases? Thank you. Well, First of all, it's pity I cannot be with you, Kim. So thank you very much for your question. It's indeed a very interesting question. I would support the previous speakers. Actually, Mr. Broker mentioned that he is head of land constitution. What I need to say, the German justice is very similar to Austrian judicial system. On the other hand, many people would agree with how scarce they work together. And actually, Austrian constitution was mentioned here. So this he also stressed that this principle, that's the principle of legal certainty, and I would say that's part of our constitution too. It's a very important component of our constitution. So, respectively, there is a point that an individual who has already received a judgment that had become effective, this individual should be sure that this judgment would be implemented. Let's say I want to build a house, I have a necessary permits, and I can start building it. I can hire a contractor to build this house. So you understand that if something happened and it goes retroactively, there will be huge damages. So it's all about legal certainty. Of course, there is a certain tension between this principle and the principle of a state based on the rule of law. In particular, what I deal with, I have to make decision, let's say, for, say, expulsion of foreign individuals to other countries like Iraq. But we know they have huge problems with, say, support, like even medical support in those countries. So actually we need to think very well about the violation, potential violation of human rights before we deliver any judgment concerning the extradition. Plus, the European Convention on Human Rights is part of our Austrian constitution, and the human rights are indeed quite well defined. But what may happen that a judge might not consider these aspects in full. Certainly, certain damages will be caused to the applicant because imagine an applicant already has a judgment, and then all of a sudden this judgment is revised. Mr. Vlachis already mentioned the constitutional principles when some judgments are then squashed by the Constitutional Court. So actually, indeed, I would rather be for a proactive approach, but still the Constitutional Court has this legislative opportunity. Like, for instance, recently they abolished one of the provisions on foreign, and then they held that 6 months would be given to the public administrations in order to ensure compliance, so that legal provision then lasted for another 6 months. Thank you very much, Ivo. I'd like to continue our discussion, and I'd like to suggest to put on the screen some quotes and participants, those who unfortunately have not been able to join. Well, that's the quotation actually from Michael Sanchez, professor of at National University, director of Research Institute for Comparative Public Law. He's one of the leading experts in constitutional law in Ukraine, and in particular, he mentioned that Article 3 adds some substance to Article 152.2, which obliges the administration to restore the violated rights. So there is an obligation to restore the violated right from the moment when it was violated. Hanna Christova, head of the Council of Europe Project International Disputes for Ukraine, his PhD. So in particular, the material she mentioned that even in the analogy of law or analogy of right is applied for fulfilling legislative gaps, taking into account the limits of judicial activism, courts may not be a substitute for the legislator and create the legislative procedures of norms of substantial law, the implementation of which is required. Mr. Evidas Norkos, affiliate professor of Nicholas Romanes University, judge of the General Court of European Union, Luxembourg, and his materials in particular noted that the choice between consequences of judgments of constitutional courts on the ex nunc and ex nunc principle reflects the search for balance between individual means of protection and legal security. Thank you. Sorry. So now I'd like you, I wanted you just to draw attention to these quotes and the provisions in support of some arguments about pluses and minuses concerning this retroactivity. It's quite clear that we cannot bypass the requirement for protecting specific individuals' human rights. On the other hand, there are constitutional powers, although by nature the main purpose of a court, the very nature of the court, is about protection of human rights.
So in this context, I would like to involve Mr. Holovati in our discussion, the man who is commonly known not only at the domestic level, but also at the international level, the one who has written several monographies, several tracts on the principle of the rule of law, someone who is so zealous about the destiny of our constitution, because he was not only one of the authors of our Ukrainian constitution, but now he has every right to defend and protect it, because he is one of the judges of the Constitutional Court of Ukraine and the vice president of this court. Now I'd like to give the floor to Mr. Holovati for him to give his vision of a mechanism, a certain possibility of how it's possible to restore an individual to his or her rights based on the consideration of a constitutional complaint clearly in the context of legal certainty application, or basically within the scope of the rule of law that you began so much to speak about in Ukraine. Thank you. Thank you very, very much indeed, Mrs. Miroslava. Also to the organizers for this invitation to participate in this workshop. I don't know how we can do it. I will say right from the outset. That's first point. Although I have my own vision for that. Second point, given the fact that I have heard some things and I immediately want to cut off them because I don't want to follow them. There was an idea that the legislator has to do something at one point, and I immediately asked the question, what if he doesn't? doesn't do anything for the Ukrainian constitution. In the Ukrainian constitution, we have the institution of the constitutional complaint. What is the purpose for this institution? It's a tool to ensure and enforce human rights. Is it or is it not? Does it work? Does it not? Because otherwise we will be expecting the legislator to do something. Maybe they will do it tomorrow, maybe in some 10 years, maybe never. Next, legal certainty, something that we've heard about on a numerous occasion. The Constitutional Court over the last 2 years has adopted a lot of its decisions referring to the principle of legal certainty. But what do we talk about? Legal security is another point which is widely circulated in German legislation. Are we talking about legal security of the legal order on the one hand, and on the other hand, the right, the personal right of an individual, because it's a complaint, an individual complaint, personal complaint, a complaint of one person or one individual applied to the court. That's the balance that the last quotation was about. And another general character remark, and then I will speak more specifically. So far, we are talking and we are having the discussion in terms of assessing or appraising the average temperature in a hospital, if you like. There are patients with the temperature 36.6, but there are some with 39.2 temperature. We're talking about the average temperature. That is to say that we're talking about legal consequences and effects of the decisions of the Constitutional Court with regard to human rights, regardless of the form of this application, whether it's a constitutional complaint or a constitutional appeal. I will be speaking about an individual complaint, constitutional complaint, because legal consequences may really vary here. They may be different, and I don't have any doubts that the decision behind the applications to do with a whole legal act or a specific prescription found in this act, that this is a decision within the proceedings in abstracto, that it cannot be extunct, and it's only ex nunc and pro futuro. But the matter of the flexible protection of the human rights of a specific individual, for me, this question still remains open, given the following. I personally, when we were implementing this institute of individual or personal complaint into the Ukrainian legislation, we pursued a certain goal. We had a certain vision why we needed that. Although, let me remark that the institute of an individual complaint in the Ukrainian constitutional legal order, Ukraine probably is the last of the European nations that implemented it. Before us, even the Russian Federation had done that, Turkey had done that, virtually all European countries had introduced that before Ukraine. And under the pressure of the institutes of the Council of Europe, we implemented this institute of the constitutional complaint. This was back in 2016. This was theoretically virtually in 2017 when it was approved. You see, it hasn't been yet 3 years since this institute began to be applied in practice in Ukraine. And from this perspective, we don't have a legal tradition, if you want. We can compare ourselves to legal traditions found in Germany, which has been as long as 75 years after the end of the Second World War, Austria, or even the countries of the post-Soviet space, Baltic countries, which are members of the European Union. Our legal tradition, our legal knowledge and expertise, the quality of the Ukrainian legislation, the quality of the Ukrainian judiciary, including the quality of judges themselves and their knowledge and expertise. Does it have to be taken into consideration in order to define for ourselves what exactly do we need within the framework of the Ukrainian domestic constitutional and legal law? What do we have to see for the full development of this institute. Therefore, given our intentions, original intentions, and we may speak here not only about the intentions of those who are making the draft of the constitutional amendments, also the legislators' intentions. When the legislature enshrined that in the Constitution, they said that the institute of the individual complaint belongs to the remedies of human rights. So these are one of the remedies, just what it says in Article 13 of the European Convention, identical language. And a person can apply to the Constitutional Court after he or she has exhausted other domestic remedies. In other words, there is a certain chain formed. All of the institutes of legal protection, remedies, including the Constitutional Court, plus there is also the sovereign jurisdiction found in Strasbourg. And so, and hence, I have a question. If the institute of the individual complaint within the framework of the constitutional law and order is regarded in the context of the notion of effective remedy to ensure human rights, which is the condition of Article 13 and the language of this article. It's an effective means of human rights protection. So what is its effectiveness for an individual if a constitutional court adopts a decision and it has pro futuro and ex nunc effect? An individual comes to the constitutional court with a complaint, and an individual complaint, first of all, refers to the jurisdiction of administrative courts. It's true. So what do they hope for, these individuals? They hope for their rights to be protected. They hope, these individuals, that there will be some form of protection ensured. Maybe their human rights will be reinstated and restored, or Article 56 of the Constitution will be effective. It's been 25 years since its adoption, but this article virtually remains very passive. The right to compensation of the damages inflicted on this individual by actions or inactivity of public authorities. So in one way or another, a complaining individual hopes that their rights will be restored, that their rights will be protected. And so they come to the Constitutional Court. Moreover, the national legislator also establishes the things probably which are not available in other countries. I haven't studied yet, but it's possible. If you apply to Strasbourg, the domestic legislation in Ukraine says that the decision of the Strasbourg court becomes the reason to review this judgment. And we have it enshrined in several codes and other jurisdictions. In commercial, criminal, administrative jurisdictions, it's enshrined that this is the decision of the Constitutional Court becomes the ground for review. And what kind of review are we talking about? If this review or revision is another link in the Ukrainian national law and order, which allows an individual to maintain hope that the case will be revisited because their rights and freedoms were violated, maybe it's incorrect. Maybe we need to remove these norms from the domestic legislation about the grounds for revision based on the decisions of the Constitutional Court after the application of the individual complaint. Maybe so, maybe not. But if we have such an institute of revision in place according to our decision, then it means this encourages an individual to apply to the Constitutional Court. If an individual knew that the decisions of the Constitutional Court decision is ex nunc and pro futuro effect, why should they come to us? Let them go to Strasbourg. At least there they will have the pecuniary damages compensated to the amount of 1,000 euros, because Constitutional Court is absolutely redundant then. I mean, the domestic Constitutional Court is just a club because its judgment for this individual will be in the format of ex nunc and pro futuro. So given all of these things, it's natural that a lot depends on the legislator, but a lot also depends on case law, on judiciary practice. For this reason, I would like to focus everyone's attention. Yes, I see that you're giving me a cue. I'm giving you 1 more minute. So I would like to say that while some are reading about the actions of legislators, that we have to nudge, push, and encourage the legislator, we ourselves have to determine it for ourselves. Maybe the administrative constitutional court, are we progressing forward and pursuing the goal which was clearly defined by another article of the Constitution? I've already stressed Article 56. But not every constitution has a formula in place, which is a formula in Article 8, which speaks about the principle of the rule of law. And it says that it's not just recognized as the foundation for the law and order and political order in the European countries, but it says that it is in effect. So if the effect of the rule of law is in place, so this is an organic connection with the other means and remedies, then the individual complaint is an institute which effectively protects. So does it remain only theoretical for the future? Sorry, practical only for the future? Will it be effective for an individual who comes to the Constitutional Court with a complaint? So let me repeat by saying that from my perspective, moreover, we also have one more problem in place. The problem of legalese, legal language or understanding, because in the German legal system, there is a distinction between the doctrine of nullity, something that we recognize to be void, null and void, ad initio, right from the outset, and another doctrine, invalidating effect, after it was found null. So until a certain point, it was found to be effective and legally significant, but starting at a certain point, it loses its validity. For us in the Ukrainian language, it's very difficult to distinguish between this nullity and invalidity. In our constitution, there is no clearly defined answer. And we have to still identify these issues more sharply. And we have to refer ourselves to the judgment by the Supreme Court. In the panel of judges, I will not name them, but this is case 820, dated 16 May 2019, where the panel of 3 judges, referring themselves to the judgment of the Constitutional Court of Ukraine, dated 1997 and 2010, that referred to submissions of the parliamentarians. This has nothing to do with individual complaints. So the Supreme Court interpreted by saying that Article 152 of the Constitution has to be understood in a way, once again, the Supreme Court interpreted this Article 152 of the Constitution in a way that the judgment of the Constitutional Court has no retroactive effect. It amends legislation only for the legal relations from the date of its adoption, ex nunc, and this was the judgment of the Supreme Court. So just ask yourself this question: was it the legislator who wrote it or the Supreme Court interpreting this? It was done by the Supreme Court, as I said. Therefore, I'm deeply convinced. You may not support me here. I may remain completely alone in the legal system of Ukraine and in the legal community. But my opinion is that we have to specifically choose for ourselves, as we are building now our national constitutional tradition, in the framework of which we have implemented the National Institute of Individual Complaint, because it's really unlike the institutes. It's much more complicated than other institutes of similar type. We don't have any legal traditions, as I said, and I believe that we have to select between these two German traditions, nullity and invalidation. Also between annulment and derogation. It's very difficult to explain for translators because they will find lots of similar translation. It will still speak about quashing a decision, but still all of these things will be different in a way. So I believe that if the Constitutional Court invalidates or derogates a particular norm of the law, invalidates, but it used to be effective. But at a certain point, a situation comes when this norm is invalidated, it loses its validity on the basis of what is recognized to be unconstitutional. So if this is considered as something that refers to the future, pro futuro, if it talks about ex nunc, so the claimant that comes to the Constitutional Court sees that his case was not resolved because he wanted his rights to be protected. And removing the unconstitutional norm from the national system of legal order and law, by doing that, you still do not help this individual. Therefore, I think it's, on the one hand, relates to one individual, but if you talk about the potentiality of all other individuals, then there is no potential for these individuals to want and go for an effective remedy to ensure that and protect their human rights. Therefore, a lot of nations in the world selected the model which allows them to apply the doctrine, ex tunc model, for this specific individual on the grounds of the very famous doctrine, or the so-called premium for the catcher approach. That is to say, the one who comes gets gains because his or her rights are reinstated and restored. But I believe that given everything said, given everything that we have, and because we are a very young state and we don't have a national tradition, and this is a post-totalitarian state, at least we have to introduce. When you spoke about the exceptional cases of 82%, here we talk about an individual complaint for someone, at least who is seeking, who is using this constitutional complaint instrument as a remedy, an effective one within the framework of the national constitutional system. Thank you very much indeed. Sergei, it's always very interesting to listen to you. You encourage us, nudge us to move ahead. Dear colleagues, Lars Broker is finally with us. Can you hear us, Mr. Lars? Can we hear everyone? Also be mindful, dear friends. Please be more brief.
So now I'd like to hear from Eva Wandler. Do you have any distinguishing or different applications concerning this function of Constitutional Court? I mean, abstract control or specific case when we talk about constitutional complaint. If you just deal with declaring certain law unconstitutional. If there is an application by a certain entity or actually complainants, for instance, in our country, this is limited to the parliament, cabinet of ministers, president, a group of MPs. So do you distinguish between these two situations, and to what extent your Constitutional Court would take into account the difference between these complainants? Would the court apply different procedures in this case? Thank you. Yes, when we deal with the individual complaints, it can be done, and this individual is expected to demonstrate the fact of a violation of his or her constitutional right, which certainly where the referral can be made to, say, European Convention for Human Rights, let's say Article 6, say no hearing took place or something like that. So this this application can be filed with the Constitutional Court, and the Constitutional Court would check the judgment delivered by administrative court, and if the Constitutional Court has any doubts concerning a judgment or specific legislative provision regarding its constitutionality, then the Constitutional Court would undertake the verification of this provision. Say, for an individual, it would probably give the desired result. Well, they start this verification procedure or consideration procedure, and depending on the outcome, this provision can be cancelled. So this result will certainly have positive effects for the individual. And thank you. But if the Constitutional Court does not find any violation of the Constitution in an administrative judgment, then this Constitutional Court would dismiss this complaint. Let's say, well, they find that no violation has taken place. But if, yes, there was violation, then they would refer this judgment back to the administrative court, but this time with the judgment of Constitutional Court, which would be binding, so that the administrative court would just, yes, very interesting experience. We saw it in your materials. We already had an opportunity to read them. That's a very interesting experience for us too. We have very little time. I'd like to invite Mr. Broker to join the discussion. The question that I have for you is as follows. If the court finds that certain judgment is not constitutional, can then this court suspend the execution until the final decision is delivered? Why I'm asking this question to you, Mr. Broker? Because you paid very specific attention in your material to this, what I would call mutual understanding or mutual respect between different jurisdictions. I mean, constitutional and administrative jurisdictions. And I'm not just asking this question for nothing, because in the previous version of the law, Constitutional Court, there was a provision which allowed for trial courts, judges, if they have any doubts concerning constitutionality of a law, the judge was allowed to suspend the consideration of the case and request the Supreme Court to address the Constitutional Court for interpretation. But that sometimes was kind of abused, and then the amendments were made to this law, and this provision was reworded. In this case, now the judge, if he has any doubts, he can deliver a judgment based on the Constitution by analogy of law. And after that, they are supposed to address the Constitutional Court. So when you are talking about this mutual respect or independence between different jurisdictions, which is a very important point, what is your opinion in spite of these changes in the legislation that exists now in the laws of the judges are allowed now to make their own decision, and only then after that ask a constitutional court. What if there is an exceptional case? If a judge cannot be really sure whether a provision is constitutional or not, should the judge would be allowed to suspend the consideration and ask Constitutional Court for their opinion? I'm asking this question because, you know, under some circumstances, Constitutional Court actually adopts the legislation, but it takes time. So can we face a situation when we declare some provisions doubtful, and the Constitutional Court after that tells that no, holds that yes, this the provision is okay, it's quite constitutional? What would you say about that? So good morning. I apologize for being late because yes, there was an accident on the highway. So yes, I'm happy to greet you all, to thank you for the opportunity to share my experience, share German experience. Yes, you described the situation quite correctly. I think my colleague from Austria has already mentioned something in this regard about the model that exists in Austria. In our circumstances, many actions need to be balanced somehow. So we need to really consider this correlation between the constitutional justice, administrative justice, and citizen. But there are many other actors, say public administration. If we consider all these actors in their totality, there is an issue. What is the right way to balance these relations and this chain? So this is actually the overarching question. I understand the points that I heard, like say if a constitutional court declares a law non-constitutional, there should be some effects for the citizen who applied. And certainly there should be some benefits, effects to citizens. But in spite of that, you probably also saw my opinion about the legal stability, legal security, things like that. So I'd like to give you an example. Let's say there is a public servant who applies, files a claim with the administrative court, stating that his salary is low. But I have 3 children, huge family, but I make just a bit more than those who obtain social benefits. And let's say the court, well, federal court actually had their opinions and doubts concerning whether the salary was sufficient or not, but these salaries are defined by law, and then the citizen filed a claim with the Federal Constitutional Court, and the Constitutional Court is not just allowed to say that maybe it's not constitutional, but they need to demonstrate why, to give proofs why it's not constitutional, and also to consider the respective case law administrative court, and then they may can make a statement concerning constitutionality. And here the plus the Constitutional Court needs to show this supporting argument. So it's actually not just up to the court to state that you know how to hold, and it's the only prerogative, sole prerogative of the Constitutional Court to declare anything non-constitutional constitutional. What happens at the same time at the administrative courts? Yes, Constitutional Court, Administrative Court may suspend the proceedings, and if within this time frame any other civil servants file their compliance, also stating that this law is wrong, then the lower courts are expected to also suspend their proceedings with this respect and wait for the Constitutional Court to deliver their judgment. So, then a smart civil servant would apply with the Constitutional Court, of course. The administrative body, although having objections, will still need to wait. So what did the Constitutional Court do? They decided these people who have many children, well, they were supposed to say that actually this law from the very beginning was null. But actually, the judges who make their salaries indeed a lot of money, they have not earned this money right away in a moment. And they did what they stated. They stated the Constitutional Court cannot print the money. But as far as completed cases were concerned, these civil servants certainly will not be compensated for that. But those who filed the claims and actually the Constitutional Court made conclusions to their favor. Actually, the legislators stated that they need to reconsider this law. But what will happen to other thousands and thousands of civil servants who never filed any complaints? Then the government will say, if they do not complain, then that's up to them that they like it, you know, and those who had enough cheek, you know, to dare to go against the public administration. But then the legislators will need to see whether there are sufficient funds in order to pay this money to the complainants retroactively. And here the court cannot do anything to force the legislators to do something about it. This is the German way of resolving this issue, but the key point is that the judgment that has come into effect will remain. That's about legal certainty and legal security. Let's say if there is a judgment cannot just be implemented, that's a different story, but it's rather for the authorities, administrative authorities, to see what they can do. Then they can undertake, try to implement their remedies to protect their position. So, like a stronger colleague told us that, say, our circumstances, UK filed claims against the judgments and judicial decisions. I remember there was big discussion in the country. I remember that we were talking that only cassation complaints against law should be admissible. What we're doing now is, to some extent, the effect, the consequence of their decision. And the Constitutional Court, under such circumstances, stated there, yes, we want it to be executed and implemented. I think that it depends on the system. It depends how wide is the path allowed, given to the Constitutional Court. Well, but this is the situation in Germany. Not all politicians like it, but in our country it's very easy to apply, file an application with the Federal Constitutional Court. They receive about 7,000 constitutional complaints, but only 1.4% are satisfied. So that's not bad for public administration. And another important point is that the courts indeed can suspend the proceedings. And sometimes it takes 2 or 3 years, and the claimant just has to wait. But we also have some urgent remedies. We call it pending judgment or pending, like a pending breach, when it's kind of something interim, when they just do kind of inquest during the initial stage, and they provide for temporary remedy. Thank you very much, Mr. Broker. In the second part of the session, and it's a pity we couldn't see from the very beginning. Dear colleagues, let me draw your attention to the fact that the time is running really fast. The discussion is great. I think we'll continue discussing this topic, maybe in a wider way.
The same questions of the same survey are posted on your screen. So do you think that in Ukraine, the retrospective effect of the decision concerning unconstitutionality of a certain act in order to protect human rights is completely expedient or appropriate? Only in exceptional cases it can be applied, or absolutely unacceptable? Dear participants, we are completing our survey. Thank you for participation in it. Thank you to all of the participants. And now let us see their results. Could you please present the results on the screen? Let us see how our vote was at the beginning of our discussion. Here it is, the initial survey results. So let me stress again that to the question posted, the audience responded in the following way: the retrospective effect of the decision concerning the unconstitutionality of an act, 33% it was completely appropriate, 72% found that it was possible in exceptional cases, and completely unacceptable by 5% of voters. Now, please, Ms. Maria, post on the screen our final results. So what do we observe? We see that in answer to the retrospective effect of the decisions concerning finding unconstitutional certain acts to ensure human rights, the retrospective effect as a remedy was selected by 37% of voters compared to 33%. So we can see that the number of the audience voting in favor of this point has increased. They believe that this retrospective effect is appropriate. concerning the possibility of using retroactive effect only in exceptional cases in order to restore fairness. Here the indicator has dropped to 58% in comparison to the previous survey, in which 72% voted in favor of this option, the exceptional approach to applying retrospective effect. And the same indicator of 5% of the voters still believe that retrospective effect is unacceptable for our system. Mrs. Miroslava, I believe that in the first vote, there was a mistake. It's impossible to have so much percent, because otherwise it would have gone beyond 100%. So probably for the first selection, it was 23 or 62% for the second one, because otherwise we will not have 100. We calculated differently. Here, one answer is 100%. Oh, I see what you mean. It's a slightly different indicator. So it's not the sum total, so it can be more than 100%. Yes, it can. Yes, just like during the elections or at the referendum. Thank you, Mr. Holovati. Now please turn off all of your microphones. So now we are completing. But before we do that, I would like to talk about certain conclusions. First of all, of course, we would like to say certain things before we wrap up, but we'll probably talk about it at greater length in the second session. I really like the foreign experience that our speakers shared when retroactivity is considered to be an exception to the rule that has to be clearly defined. So when we speak about legal certainty and the concept of res judicata, which means a certain predictability and a part of the rule of law principle, and clearly the rule of law in our activity is a key principle. All are equal before the law, and a person must understand the potential consequences of his or her actions if he or she breaks the law. At the same time, the same principle, that is retrospective effect, it is aimed at fair treatment of the person and restoring this treatment. And it is within the scope of the rule of law, exceptions to legal certainty or predictability are allowed in order to restore one goal, justice. They can be embodied in terms of proportionality and balance, which force the judge to weigh between the human rights and the security of the judiciary or the state as a whole. Therefore, at this point, I would like to thank all of our panelists for their today's participation. And next, we can continue talking. We see that we have a lot of potential. Thank you for the time that you have made. Thank you for your attention, attentiveness to each other, for the timing that you have applied. Unfortunately, we have been limited, and sometimes I had to remind you about these restrictions. Thank you for your understanding. And I hope the participants and the audience of the first session, of the first panel discussion, will be involved in the second panel discussion as listeners. Because in the second session, we'll be discussing practical issues related to this subject matter. And now we are announcing a break of 20 minutes. Again, thank you very much for your attention, and see you in 20 minutes.